C. They're both called 2019-0234 and 2019. Court of Appeals. This morning's oral argument calendar has two case numbers on it. C.R.C. They're both called 2019-0234 and 2019-0233. Let me just put on the record, or get your input on the record about how these cases are going to proceed. Are they both going to be argued separately, or are they going to be argued together?
So, Your Honor, father's petition rises and falls with mother's. So I represent mother, and so does Jeff Ross. We thought that we argue mothers first, and then if the court has any questions for father, we submit hearing Rollins' father's attorney. We'll be resolved to be willing to answer any questions. But essentially, we just spend the bulk of the argument with father's case.
All right, is that acceptable to the guardian?
That makes sense.
Okay. And the other thing I want to make a record of this morning, I guess there's been some planes, trains, and automobiles issues this morning. Ms. Adams, good to have you here. Mr. Peterson is still not quite with us, although I understand he's on his way. So hopefully he'll be bursting through the door at any moment. Hopefully we'll be part of the argument as well.
Although he has also been informed that he needs to be on his way.
Yeah, he wasn't on his calendar today, I guess. So whatever he has to say will be, I suppose, on the fly. We look forward to hearing whatever he wants to share with us today. Okay. Any other questions before we begin? In terms of 12 minutes on the clock, does that mean there's been a communication about rebuttal time?
Yes, sir.
3 minutes for rebuttal?
Yes, sir.
You all have been here often enough for me to probably dispense with the rest of my spiel. Just remember to stay close to the microphone while you're speaking. So you're good. Okay, Ms. Adams, whenever you're ready.
Thank you, Your Honor. Your Honor, my name is Emily Adams, and at my table is Jeff Ross, and we represent mother in this case. Also at my table is Erin Ross, and she represents mother. In most child welfare proceedings in front of this court, parents don't think they have very much of a chance. Oftentimes they have not done enough to correct the situation that led to their children's removal, or they didn't do enough quick enough. And so we ended up having cases where, a lot of times parents who have had drug addictions, they just are still addicted to drugs, or parents who have emotional abuse issues to go to therapy, or parents who have mental health problems, not taking the medication. This is a real exceptional case where the district court really there wasn't sufficient evidence to determine that there were grounds to terminate mother's parental rights, or that it was in the best interest of the child. The court terminated mother's parental rights because of three things essentially. First, her mental deficiency, which is a low IQ, and then the court also said that there was failure of parental adjustment and that she didn't remedy the situation that led to the children's hospital placement. Now, the court also did mention just briefly fitness and neglect, but that was all wrapped into its mental deficiency analysis. The main reason that the court terminated mother's parental rights was because of her mental deficiency.
So you're reading the court's ruling and saying she was unfit because of mental deficiency?
Yes, and I think it's very clear when the court goes through the grounds for termination section that the grounds that the court lists is her mental deficiency. And that was what the bulk of the trial was about. It was about what her abilities were and about her communication with father.
Right, and I was going to say, isn't that really what the bulk of the trial is about?
Her communication with father.
Yeah.
Well, that was the reason that they ended up getting to termination, Your Honor, was because of the fact that she communicated with father. But really, the vast majority of the state's experts, and we have the DCFS clinical consultant, we have the Dr. Giesinger, who was the DCFS doctor. All of these people talked a lot about her abilities and what she could and could not do with her IQ. And that was what really supported a lot of what the court discussed in its order.
I think I understand that, but even if we put that to one side, is there still grounds for termination based on the risk that the children would be unsafe in her care because she wants to reconcile with father?
No, Your Honor, I don't think so. First off, father is in prison for 1 to 15 years. He's going to be in prison for a really big long time. Secondly, there's no evidence that he abused the children. I'm not trying to justify his conduct in any way, shape, or form. He did possess child pornography, and that was a crime.
It doesn't involve his children.
But none of it involved his children, and we have the psychosexual evaluation. So it's really quite frankly an awful test that people go through that says that he's low risk. There is a case I cited in the reply from New York where there was a parent who did involve the child in child pornography. And in that instance, of course, the child should be removed. Of course, the child is at risk. But in this case, the child is not at risk. There's just no evidence that he ever abused his child, any child. And what's interesting in this case is there was a lot of questions about potential future harm because of mother's intellectual issues. And all we know about father is that he possessed child pornography. There was never any allegation that this was an abusive relationship, a manipulative relationship. There was no evidence of that at all. It's just he made a really stupid mistake with child pornography.
Part of the low risk finding though, wasn't it, was that he was, he may be low risk if you were under some probationary conditions.
Yes, you're right.
That included no contact with children.
And that's something that they would need to figure out in the future.
And how would you figure that out? I mean, if he's supposed to have no contact with the children, do you have thoughts on that?
Well, Your Honor, that's something that I think that's a bridge they would cross when they get to it. Father would have, when he gets out of prison in a very long time, he would need to abide by the terms of the PO sets on. And the probation officers are very strict, and he would need a separate permit. And, the thing is that mother can show that she can keep the children apart from him. I mean, the reason that she had a problem to begin with, the reason that they sought to remove the children was because dad was in jail, I believe, on these charges. And she brought the children to the jail to visit with dad, and there was no contact order in place. And DCFS said, we can't do that, and they reminded her multiple times that she wasn't to disobey no contact order, and yet she did. And so the children were removed, and they made it very clear in the parenting plan, the child and family plan, that she would not have any contact between the children and the father. And at that point, she had 2 children, one of them died on DCFS house. And so, and she never, even though father was making a lot of calls to mother, there's not a single bit of evidence that she ever let the father talk to children. And so I think that mother knows how to set this boundary. Yes, she did express 1 or 2 times that, she wanted to get back to him. But I think that given the choice between, keep your children, you've got to stay with them. I think that she was given that choice. And her conduct is consistent with that.
Wasn't she given that choice?
The problem is, Your Honor, no. It was never on the child and family plan that she had to see with the father. So the child and family plan is on pages 101 to 106 of the record. And on that, it lists 11 points that mother needed to do. And not one of them says that she's disabled. DCFS said it was implicit in the plan, but when it's not explicitly part of the plan, I really struggle with that. She fulfilled every single provision in the child and family plan. This is a woman who was doing everything she could to get her children right. But the court said, and to me, there just wasn't enough evidence to support that decision. The court also said that beyond her mental deficiency, that there was a failure of parental adjustment. And the GAL does point out that there's a definition of parental adjustment in the Act, and then there's also another provision, and we say that open our briefs to talk about what's evidence of parental adjustment. They're slightly different, but the common theme is that there's substantial compliance or substantial correct the reasons that lead to the children's out of imprisonment. She completed her entire plan.
Except that she couldn't find that support system, and isn't that critical? Because if she was not capable of caring for the children completely on her own, she really needed someone like her mother or like this neighbor to assist her. And if she can't maintain that, then isn't that in and of itself enough for termination?
No, Your Honor. So the state says in its brief that mother needed a full-time, in-home person to help her care for the children. And that just was not the evidence. All we have is Dr. Biesinger, who is the DCFS expert, who says that he would be concerned if she didn't have somebody there to help her. I guess father was a big help when he was in the home. But the DCFS, Dr. Biesinger said he would be concerned if somebody was not home with her. There's no evidence that she couldn't do it on her own. She went through several months of a peer parent, and that peer parent, had to help her a lot at the beginning, which I think is really normal with all these types of situations. But they could step back more and more and more and more as the process went on. And the DCFS clinical consultant who observed parenting time between the mother and children at that point noted that she did an absolute fine job. And that the expert, the peer parent didn't help out.
Wasn't though a lot of the testimony to the effect that she was ultimately able to learn how to change diapers and feed children and that sort of thing, but that everybody was concerned about what was going to happen when the kids started to develop, and that the developmental complexities would just be too much for her to keep over time. Yeah.
So there was some concern about that, Your Honor, but I think that that does not raise the clear convincing evidence that she was unable to care for the, I think the standard is current and future needs of the children. Clearly she could care for the current needs of the children. The child in this case is young. She's about 2.5, I believe, right now. And she could do the tasks of caring for that child. And as the child gets older, things do get more complex, but there's no evidence that she can't do it. There is concern because she has a low IQ, but Dr. Beesener testified to the court that low IQ is not determinative. What's determinative is, can someone learn, can someone grow, are they capable, are they coachable? And all the evidence on the record is that she is this way, that she can learn, that she can adjust. And the DCFS clinical consultant who observed the parenting session was asked, well, the clinical consultant testified he was concerned that she wouldn't be able to care for the children as they mature and get older. But he admitted that that was just speculation. We just don't have clear and convincing evidence that she cannot care for this child as the child is older. Now, there might be a point where that happens. And if that point comes, then the state can step in and it will have some evidence. But right now, all we have is speculation. We have no clear and convincing evidence that she cannot care for this child. And for so that she can't care for the child now, and she can't care for the child in the future. And as Your Honors read the record, I think it's very clear that she surprised everyone. She surprised the judge, she surprised her own attorney, she surprised the opposing counsel about what she was able to do. I think that we can expect that she'll surprise us again in the future as she's caring for this child. The other prong is she failed to remedy a situation that led to the out-of-home placement. The reason that the children were placed out of home was because of the mother allowing children contact with the father. And it's very clear that she couldn't do that. There was no evidence at trial that she didn't do that.
That was remedied because father was put behind bars.
Well, the reason.
And we have some evidence that she has some desire or intent to get back with father as soon as he's out.
Well, it wasn't remedied because father was put behind bars. Father was put behind bars, and the children were still in the home. And then the reason the children were removed was because she was taking the children to the father, and she was allowing the children to talk to the father. So that was the reason the children.
So after the children were taken from the home, she never took them to the jail again. And taking the children to the jail to see father was the reason they were removed in the first place,
Exactly.
in violation of the no contact order.
Exactly. So that was the reason the children were removed.
And then one of the conditions was that she did not allow the father any contact with the children. She never took them to see him again.
She never took them to see them again. There's no evidence that she had talked with father. There was just no evidence that she allowed any contact between father and children.
But to Judge Harris's point, there is evidence that she talked about reuniting with the father and having her family back together once he was released. Why shouldn't that concern us?
It shouldn't concern us, because it's based on all of her conduct up until this point. She was willing to do what DCF asked her to reunite her to keep her children. And father's supposed to be in prison for a very long time. Those statements, people make statements like that and don't do anything. I mean, I guess when we look at people's actions and what they say, the actions are what they speak about in words. And here, what we have is she's doing everything DCF is asking her to do.
But it does make me a little bit worried that it's only because she had these scheduled visits. I mean, she even said that if she had an overnight visit, she might run off to go live with her father. I mean, it seems like the evidence supports the judge's finding that the only reason she's complying is because the circumstances are as they are. The husband's in jail. There's these very controlled visits. She doesn't have the children or the child full time And the concern is that if the children were placed back into her home, all of this would revert based on her own statements.
So she did make one or two unpressed statements from her, but I don't think that we can say that it completely, oh, I'm sorry, I'm not telling you, maybe that's what
Please, go ahead.
What we have here is someone who was just shown consistently over time that she was willing to do everything that she was required to do. And I think the controlled circumstances did help in some way, especially because frankly she needed some training and some coaching and some learning to learn how to care for these children. But I don't think that she would, I mean, she didn't make, we don't see her making any efforts to run medical children. We don't see her taking the kids and leaving during a visit when the peer parent has like turned her back. We don't, there's just a lot of things that if somebody really was planning on taking the kids involved, there would have been a lot of like things that they would have done. I think we would have seen all that evidence on the record. We don't see that here. What we see is her fully engaging with her children when they're staying with her. We see her fully engaging with her peer parents and learning. I mean, the peer parents testimony is really important in showing that this was a person who really wanted to change. She was being taught this parenting skill and she was applying it. And she was good at applying it. And the DCFS clinical report even said that she was good at applying it. She was learning and she was trying. And so I think we have to take that same with a grain of salt and compare it to her actions. Because she's doing everything she can possibly do to correct the circumstances, to correct the situations that her children are experiencing. Does that answer sort of the roundabout?
Thank you, Ms. Adams. Okay, Mr. Peterson, welcome. Glad you're here. And you may not have time.
Usually, I found a tie in my office, and I'm good. Sorry, our calendar completely fell down. I love it, council as well.
We're glad you're here, Mr. Peterson. Okay, so how are you guys going to divide your time? Okay, Ms. Pierce.
And I do have to say, I've never seen Mr. Peterson do this, so, and I haven't used up my grace. It can happen to any of us.
It can. We're glad you're both here, so please proceed.
Parental rights are, these are correct words. Here's attorney guardian ad litem for the minor child. Parental rights are a function of parental duties. The Supreme Court has said that the correlative of parental rights is parental duties. Children's best interests are a function of children's developmental needs. You just heard counsel argue the evidence. That's what you do in trial. But on appeal, you argue the law because this court has to give evidence to the weight, inferences to credibility, has to defer to the trial court. I submit that even if I granted her, okay, no children were harmed, okay, set aside mother's low IQ, okay, I'll grant that mother did every task on the treatment plan. You still have evidence because she proved she cannot protect. And you can't say she didn't know she wasn't supposed to be with father because she knew enough to lie about it. She knew enough to dissemble. And she did try to have a little with her child. The father talked to the little child at Thanksgiving when she was at the foster mom's house. She wanted father to talk to the child. She sat right in front of the foster mom. The issue of harm. Under 508.2, it lists these different sexual offenses that create a rebuttable presumption of unfitness. Many of them do not involve harm. Some of those, voyeurism, sexual offense of another child, they all involve attempt. So harm is not what the legislature was looking for. They were looking for harm and threat of harm. So that's a legislative issue. So it does not rebut 502. You're looking at me like,
No?
okay, I saw a question bubbling out there.
No, if I have one, I'll ask it, Ms.
Okay, I know, and I just thought I saw that. Mother never got to the point of unsupervised visitation. And as you recall, when the child was brought into care, she had failure to thrive. She was filthy and she had failure to thrive. And we have a pretty good guess that was because of mother, because the minute she was in foster care, she began gaining weight and catching up developmentally. So that was an issue as well. What we do know about mom is we can't trust her to tell the truth. We can't trust her to protect this child. Even if this father is going to be in prison for the rest of his life, We still can't trust her, because what about the next man? What about, she just has not shown the judgment that it takes to protect a child. And the legislature has said that the child has a right to protection, that's under 62A 4A 201. As far as best interest is concerned, under 62A 4A 205, it says when a child is less than 3 years of age, you can't return home unless there's a compelling reason. The permanency plan shall be adoption. So we've got some very strong legal presumptions that support what the judge did. Counsels are arguing weight of evidence, inference, credibility, and that doesn't work in appellate court.
Okay, so our standard is sufficiency, right?
Sufficiency, right.
And Ms. Adams talked about the clear and convincing evidence.
Right.
So when we look at this, as an appellate court from a sufficiency standpoint, what is sufficient evidence to support the
But that was
juvenile
the
judge's
issue in
findings?
Ray B.R. That was, in Ray B.R., the Court of Appeals got overturned because they didn't use the proper standard of review. And in Ray B.R. said that if the record supports what the judge did, that even if it's a closed case, you have to defer. So I think that the B.R. case, 20782, paragraph 12, is the clearest statement about how the Court of Appeals looks at sufficiency of evidence.
Okay, so the point you made about the evidence down below indicating that this parent doesn't quite have the judgment to keep these children safe. What evidence in particular are you referring to when you say that?
Well, a huge one is mother never got to the point where she could take care of this child by herself. That never happened. So anything people were impressed with, it was because she had somebody watching her and coaching her and helping her.
That was a determination DCFS or somebody would have had to have made at some point, and they didn't.
Mother could have petitioned, anyone could have petitioned for unsupervised visitation. That never happened. So her own counsel could have, anyone could have. That didn't happen. So that's very clear. And then her lying left and right about her contact with father and her plans with father. And then what she would say when she knew that she was being watched, well, I'll jump out the window, I'll pick my kids and jump out the window, I'll do this, I'll do that. She can't be trusted.
No, I'm just not sure how I understand the idea that if she's planning to reconcile with the father, that poses a danger to the children. But speaking with the father and lying to DCFS about it, how does that bear on her fitness as a parent?
It absolutely bears, because we know she knows what to say what people want to hear. So she could move wrong when somebody's watching her, she can say the right things when somebody's watching her, but we know when she thinks they're not listening to her, what she will do. And even then she slips, like she had father talk to the child at Thanksgiving, and she took a call from her husband right in front of the kids with her waiting for court. So they're just, and she never got to unsupervised visitation because nobody trusted her. So she has proved that she can't protect it. She can't take care of her child unsupervised, and she can't protect her child. And the legislature is really clear about wanting to be protected.
Is it a problem that the expert, I can't remember the doctor's name at this point, Dr. Singer, only evaluated her before the peer parenting? Because when the opinion that she could not care for a child on her own was before she had all of the training and the support, do we need another evaluation at the end so that
It
it's
would be
current?
helpful because if you read Dr. B. Singer's evaluation, most of his tests he said were invalid because she gave invalid answers. So, and he never saw her with the child. So, in the evaluation, he said he really had little to go on. And again, she dissembled a lot to him. Because he would say, well, here's what she told me, and here's what my collateral sources say, and here's why these tests that I gave her are invalid. So I think if she had a second psychological evaluation, the same thing would happen. It would not be valid. Any questions? Thank you for your time.
Thank you, Ms. Peterson. I guess the rest of the time is yours.
Okay, please, Court Dr. Peterson, I'm going to thank you again for waiting for me. Just starting off where we left off there, the important thing to note is, not only, lying is not good, obviously, but it does take an ask like why that isn't a very effective parenting. I think part of the problem, I think it was Dr. Beeson here, not there, but who said that part of one of the problem is that not only does the reason why she's so enraptured with father is because her limitations make her easy prey for people like father. But I think part of that that shows is if it's not father, it's going to be somebody else. Because she's not a person who can really take care of herself, not to mention the children. And so she's the sort of person who is likely to be preyed upon over and over again. And I think that her conduct shows that how easily she's manipulated. I mean, she doesn't just speak to occasionally. It was almost every day or multiple times a day. She also spent $2,000 for money stuck into the prison account, money that she needs to take care of children. And these things show that she will easily put these relationships well before her children and any kind of common sense.
But there was no restriction on her giving him money, right?
No, but it does show very bad judgment. I mean, you're trying to demonstrate that you can provide for children and you can barely provide them as it is, and you're giving away money to your dirtbag husband in prison. I mean, it doesn't show for judgment. It doesn't show somebody who's willing to put her children before a child molester in prison.
Oh, there's no evidence that he
Okay,
was children, is that
we're
right?
not a pornography professor.
Okay, I just wanted to clarify that.
Yeah. I mean, I think also, Helen said that the only person who said that she needed assistance was Mr. Beecher, and that's not true. If you look at my brief with 13 work, I said everybody, including mother and father, agreed that mother said she's never ever carried her child alone. She always had police had father brought her up. Father said, they had struggle. They had to call California Social Services even when he was in the picture. Dr. Biesinger, Mr. Baird, Jennifer Fastbull, every single one of those people, I cited in my brief, said the mother can have care for children on her own. So it wasn't a limited opinion. It wasn't just Dr. Biesinger. It wasn't just one evaluation. That was pretty much across the board, unanimous opinion of everybody involved in this case.
Do you think the stronger argument for termination is that she's an unfit parent because of her mental deficiencies and she can't care for the children? Or do you think it's that she can't keep the children safe because of her lack of judgment and desire to reconcile with the father?
I mean, I would say that they're really part and parcel of the same problem. Overall, I mean, she is not able to care. There's a variety of reasons. Her intellectual deficiencies make her unable to do basic things. I mean, she learned to do diapering and feeding and basic kind of rote tasks, but would come down to like complicated problem solving or like an emergency. Both Dr. Biesinger and Mr. Baird said, Mr. Baird said maybe she could be a babysitter, but if something happened, I wouldn't want her to be the one who has to like make the emergency call and deal with it in the middle of the night. She's not that person. I mean, it's pretty clear for everybody to testify that simply, not this very mother did try very hard. She learned some tasks, but that's the extent of her abilities are learning some tasks. She doesn't have the complex problem-solving skill to deal with emergencies, not to mention, teenagers and all their trials and tribulations, and they start becoming much more intellectually developed.
But we're in a different position than the trial court, correct? We're in a different situation than the trial court, right? So the trial court hears all of this evidence, and the trial court, what's for the sake of argument, couldn't go either way on this. And the trial court went the way that it did. How ought we to be evaluating what the trial court did?
Well, I mean, this court is always substantially deferred to juvenile courts on the basis of the fact the court is hearing live testimony, and most critically, the mother is right in front of the court. They've been this case going on for months and months and months, and they saw her in front of the court on a routine basis in review hearing for her testify. Heard the people, all the witnesses testify. So the court has a considerable breadth of knowledge about the factual determination this court could really possibly have from the record as it stands written. So this court is always deferred to, the appellate court is always deferred to trial courts, and this court is particularly deferred to juvenile courts, given that juvenile courts have such extensive experience with the parties in front of them for over a period of time. As the evidence Pierce noted, another doesn't have somewhat of a proven track record of failure. As you know, there hasn't been a reevaluation, but this case started out not only because, obviously she was taking children to see father, but TZ with that removal, we had failure to thrive and was not being well cared for. So it does suggest that mother was not that great of a custodian for the child, as the child is fine when she is placed into foster care. And I mean, back again, didn't quite answer your complete question about which is one or the other, because I think it really is both. I mean, I think they both really stem from her intellectual limitation. She's not a good judge of character. She's not, I mean, her continued allegiance to father, despite all the evidence of wrongdoing. And I mean, it doesn't have very good judgment. And I believe with Dr. Biesinger, who said that's part of an aspect of her personality type, that she is easy prey for people to take advantage of. Is simply that she does have intellectual limitations, and she's not really a particularly good judge of character. I mean, the fact that she wanted to abscond with the children and then run off the father and have more babies with a child pornography viewer, that even suggests a person who doesn't really have very good decision-making skills, to say the least. So I would argue that really those, you can't say that it's just her inability to care for the kid, or it's just her continued loyalty to father. Those are all part of the same just general problem, that she just simply doesn't have the abilities that are necessary to be a good parent. I think I'm all up. If there are no further questions. Thank you very much.
Thank you, Mr. Peterson. Ms. Adams?
Emily Adams, another, just a few points. The insufficient evidence is really high, but we can get over it in this case. Because there was so much testimony that mother could not care for the children long term, and that was all speculation and guesswork. We have, mother and father didn't testify at trial, like the state said, and there really wasn't any unanimous opinion at trial that mother absolutely needed 100% somebody in home to help care for the child. Both Dr. Biesinger and the C.R.C. clinical consultant said that any assertion about her long-term abilities to care for her children was unknown. Nobody knew. And when something is unknown, that does not reach the level of sufficient evidence under the law. Dr. Biesinger said that a low IQ is not determinative of someone's abilities. So I think Judge Hagan, you asked that question about whether there could be a second evaluation there. When your first evaluation says that low IQ is not determinative, and it depends on how somebody reacts and if they're responsive to coaching, then you absolutely need another evaluation. Absolutely. After you've been through months of therapy. And I think that when you rely on just an evaluation that's done before, at the very beginning of the case, when frankly mother did have issues, but she changed. You need another evaluation. You really do need another evaluation. Mother did ask for unsupervised visitation throughout the case. It's on her. She asked for it and asked for it and asked for it and was denied. And there came a point where the peer parent actually asked for it.
Denied by whom? The court or DCFS?
So, one more time.
Denied by whom?
I think she was denied by DCFS. Denied by DCFS, right? And the testimony of the peer parent, and I unfortunately don't have the record of it, but it's in the briefing. DCFS, the peer parents asked for DCFS supervisor, why don't you have unsupervised visitation at this point? Because the peer parent who spent the most time with mother believed that she progressed to the point where unsupervised visitation would be appropriate.
Why didn't she ask the court to change that prior to its decision?
Your Honor, that's a really good question. I don't have an answer for that. But I can look it up and I can submit a report to the court to take a look on that question. Also, Dr. Biesinger's testimony to me was probably the nail in the coffin. When he said that she could do 90% of the parenting job, but he was unsure about how she would respond to 10% of emergencies. I'm terrible in emergencies. I lit a neighbor's lawn on fire with a firework, and I flipped out. We cannot base our parenting decisions on how, we can't say that the parents cannot help their children because we don't know how they're going to respond in emergencies. Because the vast majority of parenting is not emergencies, it's toleration, and it's figuring out how to handle kids, especially at this young age. Now, I repeat, if there comes a point where mother cannot handle this child, as this child gets older, then the state can step in. But right now, everything is absolute speculation. And one last point, the state said that the problem with her low IQ is that she makes herself easy prey for future predators. There's no evidence that Paul was a predator. There's no evidence that he was manipulative, abusive, that he harmed her in any way. There's no evidence. And there's no evidence that in her past that she's been with predators. people that have been manipulative or abusive. And so the sense that she could potentially become, that she could be harmed is so very speculative. We don't have that in the past. There's no evidence that this whole entire decision was based a lot on speculation about what mother could do or could not do in the future, and that is not based on the whole decision. But as we